And we are live. Hello, everybody. I'm Spanny Brat with Fighter Cries.
And Tiffany Wise with Wicked Wise. And you all can introduce yourselves.
My name's Tanawah Downing. I'm with the We Shall Be Free tour.
Amber Diale, and I'm also with the We Shall Be Free tour.
So today, we're pretty much going to do questions because I forgot, because of all the snow and stuff, that a lot of people are working. So they were hitting my emails and my cell phone with all these questions that they want answered. And I said, I will do my best. So I know Spanny has some questions too. Do you want to go first, Spanny, or do you want me to go first? Oh, you don't want to go first?
Nope, you can go first.
All right. So the biggest question I got from some advocates that I'm working with asked me to ask you, if the Chevron case gets overturned, what does that mean for the lower courts?
I'm not familiar with the Chevron case. Yeah,
Right.
I'm not familiar with the Chevron case.
Okay, that's fine.
Yeah.
That's cool.
What are the details of it? We can have a discussion about it.
Well, I can tell you that when I was watching our news here, because I'm in Virginia, so I get the DC news.
Yeah.
The quote unquote legal experts are saying that if Chevron gets overturned, it is going to throw a wrench in the whole judiciary system.
Yeah. So at the end of the day, what I'm seeking to do is that Scripture says that if you build your house on the flawed foundation, that it's going to fall. It's eventually going to fall. So what's happened is that in 1833, the United States Supreme Court comes out in a case called Barron versus Baltimore. And what they said was that the Bill of Rights, which is the first 10 amendments to the Constitution, that those are not a restriction against state governments, rather a restriction against the federal government. Now, we know that that's fundamentally flawed. It's flawed for a number of different reasons, primarily that the fact that the Bill of Rights, which was ratified and adopted by the people on December 15th, 1791, according to the special amending procedures of Article 5, it says that once ratified, proposed amendments become part of the Constitution in all intents and purposes. So the Bill of Rights is absolutely part of the Constitution. Then when you go to Article 6, where it says that the judges in every state shall be bound thereby anything in the Constitution or laws of any state contrary notwithstanding, that establishes the obligation of the contracts that the judges entered into upon entering into their office. And they promise by oath or affirmation to fulfill a certain outcome, a certain future outcome, and that promise is codified within the constitutional contract. Therefore, the judges in every state are bound by what is in the Constitution of the United States. The judicial branch has no legal authority to be able to alter, amend, or destroy any of the provisions or guarantees of the United States Constitution. That's one of the questions that we have to the court. Because there's two issues here in America. One is that is the origin of all injustice that we're experiencing. One is tyranny, and the other is oppression. Tyranny is the unequal application of a law by a person in a position of authority, right? So when a judge decides that he's going to treat one party differently than another party, that is a tyrant, and he is committing tyranny. Oppression, on the other hand, is the creation of laws that affect one part of society differently than another. So that would be a legislation creating a law that would impact one group and not another group, which would, again, be an unequal application laws. So what we're experiencing across the board in all of America is an unequal application of laws, either by a position in a position of power or by a legislative branch, state, that is choosing to treat people differently within their domain. And so, the reality is that if the foundation is flawed, then we got to rip the flawed foundation out and rebuild the house. So in 1833, when the United States Supreme Court comes out and says, you know what, we're not going to give the people of the United States the very rights, freedoms, and immunities that they guaranteed to themselves by the adoption of the laws, then that is the judicial branch refusing to recognize the authority of the people of the United States. We create the laws. That's our responsibility, not the judicial branch. So the question is does the judicial branch have legal authority to alter, amend, or destroy any of the provisions or guarantees of the United States Constitution? The answer is no. Because the only way to change it in accordance with the special amending procedures is through an authentic act of the people. Any other way is done by a person who's in a position of authority that's refusing to recognize the authority of the people of the United States. Now, interestingly, sedition is defined as the speaking or writing of words, such as law established in order to cause disaffection of the Constitution to procure its alteration other than lawful manner. There's one way to change the Constitution because we have a rigid Constitution that is in accordance with the special amending procedures of Article 5 that is not done by judicial fiat. And as a result, Chief Justice Waite in his criminal court decided to do something contrary to the will of the people back in 1833, and he did it in order to advance the slavery institution. The reason why he made that decision was because at that time they were getting ready to bring forward the first national bank, the national bank that President Andrew Jackson ended up destroying. Well, they knew that debt was the greatest danger to any free society. Thomas Jefferson said that himself. So we knew that the states were going to sue once the central government established that first national bank. They knew they were going to sue. Well, to have standing in federal court, you have to have two things. One, you have to be directly impacted by law in question. Two, you have to represent the people or be a person. The states obviously are able to sue on behalf of the people of that state, particularly in this particular instance where they're establishing a debt-based system to enslave the people into the central government. And so in order to eliminate standing, they said, you know what, the Bill of Rights or the Constitution doesn't apply to states, and thus the states didn't have standing. They established the national bank, they put it into place. Now the states can't sue for the situation, and thus was born that first national bank. What Chief Justice Marshall and his criminal court did was they paved the way for that first national bank, and they did it by refusing to recognize and enforce the body of laws that govern this nation. But unfortunately, that created a situation where, if you can imagine, 1776, we come out and we declare our independence. We declare our ability to be able to speak and say the words that we want to say, and the right to be able to practice the religion and faith that we choose to practice and have. From 1776 until 1925, not one single United States citizen was protected as a result of this case, Barron versus Baltimore, by any of the provisions and guarantees of the United States Constitution, particularly the Bill of Rights. Because, of course, when the Supreme Court comes out and says, nope, you're not protected by any of those, then it wasn't until 1925, a case called Gitlow versus New York that came to the United States Supreme Court. And in 1925, this case said, well, do I have the freedom of speech? Right? This individual's petitioner, Gitlow. And the Supreme Court came out and said, yep, you are protected by the freedom of speech because of its codification within the Constitution's text. So all of a sudden, we found out that we're suddenly protected by the freedom of speech. And that's kind of peculiar because we all believed that we were already protected by those because it's written in the Bill of Rights. Well, that's not true. We were never protected by it because the Supreme Court came out against the will of the people, did something unlawful, legislated for the bench, and refused to recognize and enforce the authority of the people of the United States when we adopted our laws and established a contract and bound them to adherence to those laws. And that started what's known as the incorporation doctrine. And the incorporation doctrine was the Supreme Court slowly started incorporating those provisions that are contained within the Bill of Rights. So, for instance, in 1968, you had Miranda versus Arizona, which allowed for the protection of the self-incrimination clause of the Fifth Amendment. Then you had in 1966 Duncan versus Louisiana, which allowed for the guaranteed of the trial by jury in accordance with Amendment 6. The last freedom to be incorporated, last provision to be incorporated under the incorporation doctrine was in 2019. It was a case called Timms versus Indiana, and it was the excessive fines clause of the Eighth Amendment. And what the court said, it was a unanimous decision, 2019, and what they said is that the privileges and immunities of United States citizens are, at a minimum, those enumerated within the Bill of Rights, given their legal effect against interference by the states due to their codification within the Constitution's text. So that's pretty telling, right? Unanimous decision that pretty much, to sum it up, is if it's written in the Constitution, you are guaranteed of it by the Privileges and Immunities Clause, 14th Amendment. The Privileges and Immunities Clause, 14th Amendment, says no state shall create any laws that shall abridge the privileges and immunities of United States citizens. So again, 2019, Supreme Court comes out and says the privileges and immunities of United States citizens are, at a minimum, those contained within the Bill of Rights. Well, I'm going to tell you right now, there is one provision left to be incorporated, one, and that's called the grand jury clause of the Fifth Amendment. It's the last one. Every other one's been incorporated. So once we prevail on this, once we prevail on this grand jury issue, then for the very first time in American history, all United States citizens will be guaranteed every single right secured by and enumerated in the Constitution of the United States, regardless of where they choose to reside. That's why I'm so passionate about. We've been living a lie. And for the last 243 years, we have not been given those very rights that we secured for ourselves, guaranteed through our birthrights by the death and fighting and blood of our founders and forefathers. So, Once we do this, once we incorporate this last provision, then at that point in time, we can go back to Barron versus Baltimore, 1833, and say, you know what? Those particular justices that made that decision, it was always unconstitutional, because the way that you deal with the unconstitutionality of a statute is the same way that you deal with the unconstitutionality of a ruling, meaning that it is not unconstitutional from the day that it's deemed such, but from the day that it was enacted, as though it was never enacted at all, it was always unconstitutional. Chief Justice Marshall had no authority to declare that United States citizens are not guaranteed those rights secured by and enumerated in the Bill of Rights. And although 243 years later, we are now still dealing with this issue, because there are 13 states across America today that do not conduct a grand jury at all, and that's because of Barron versus Baltimore. We are going to destroy it. And once we destroy it, then guess what happens? All the progeny to that case is removed, right?
Well,
Now,
it's funny. I don't mean to cut you off. It's funny because one of the questions that I got from another person was about the grand juries, right? Or the juries, because the way I interpret the Constitution is it doesn't matter if it's criminal or civil. We are entitled to a jury trial. Am I correct, or am I interpreting
absolutely
it wrong?
You are correct. However, Barron versus Baltimore allowed for, and this still exists today. See, there's more history to it that I didn't just include, but let me give you another piece of the history. Okay, so 1833, the Marshall Court comes out and decides to legislate from the bench and refuse to recognize and enforce the body laws that govern this nation, and overstep the authority of the people of the United States when they established and adopted the supreme law of the land, the Bill of Rights. So immediate impeachment. That court introduced fraud into our system as of that moment. The highest court in the land told all the lower courts in the land that they don't have to follow and give to the people of the United States the very rights that are codified within the Constitution of the United States. That's exactly what happened. And until that court comes out and corrects that error, right, and that unconstitutional judgment, then every single act that's being done by every single court within the jurisdiction of the United States, or within the jurisdiction and purview of the Supreme Court, is acting unconstitutionally, because the highest court in the land told them that they don't have to. So until the Supreme Court comes out and corrects the fraudulent decision that was put into place and has deceived the people, then every single thing that they're doing is unlawful, because it derives from the unlawful direction given by the highest court in the land. It's as simple as that. But then you fast forward to the Taney Court, because they're the next ones that I'm attacking. First, we're gonna impeach Marshall, because we don't have to have him alive to impeach him. That's why Article 3 of the United States Constitution says the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state where which crime is said to have been committed. Why is impeachment not included in that list of crimes that require a trial by jury? Because impeachment is per se. We don't have to show that they intended to breach. There's no finding of facts that's required for impeachment. All we have to do is show that they had an obligation, they breached that obligation, and as a result, they're impeached. Article 3 of the Constitution says the judges, both of the United States and of the several states, shall maintain their office while in good behavior. And good behavior is defined as the avoidance of criminal behavior. So when you choose as a judge to engage in criminal behavior, and remember, perjury is a crime. It's a crime of public trust. And when you have a crime of public trust, the public can no longer trust you. Therefore, the moment you engage in criminal behavior, perjury, you are discharged. And we don't have to prove that you intended to do it. Therefore, they don't have to be alive to be impeached. We can impeach them right now by showing that they had an obligation to follow the will of the people. They didn't do it. And now for 243 years, we've had continued oppression of all kinds of peoples, continued discrimination of women, of gays, of blacks, of prisoners, of all these are all just groups of classifications that derive from their desire to proliferate the slavery institution, to proliferate the prison system under a false understanding that they're doing just work. But it's not just work, because it's built upon unjust principles, right? The purpose of the Constitution was to create harmony among all of the regional governments, harmony, not conflict. So when you allow for the states to be able to treat people differently, that goes against the concept of federalism. That goes against the concept of the union. We want one single group of laws that affect everybody equally, because that creates harmony. It creates, it eliminates conflict, and it ensures that all men are treated equally. But we cannot do that when we refuse to recognize and enforce the body of laws that bring unity. So again, Chief Justice Taney is the next one. And Chief Justice Taney came out in 1857 in a case called Dred Scott versus Sanford, right? Which is still cited today routinely by the Supreme Court and by lower courts, this particular case. Well, let me give you a snippet of what this case said. It said blacks are not, and were not intended to be included under the word citizen in Constitution. Blacks are so far inferior that they have no rights which the white man was bound to respect. Slaves are private property protected by the Constitution. I don't think there's a single United States citizen that would agree that that is consistent with the principles that we've established. And as a result, I don't care whether he calls himself honorable. I don't care whether his group, they made good decisions. That is not a good decision, and it must be removed from American jurisprudence immediately. We will not be known as the society that says that blacks aren't people and that they're inferior to everyone. No, it doesn't matter who they are. No one is inferior, because here in America, all men are created equal. And a man is simply a term created by Genesis that says God created us in his image. In the image of us, he created them male and female. Therefore, a man is a male or a female. That's a man. And that's what they're referring to. So every man was created with equality. Every man was created to have our own sovereignty and our ability to develop ourselves and our own cognition, our own understanding and consciousness based upon what God created. And we are not to judge each other of what God created. Not at all. We were meant to be equal, and it's time for us to fulfill that. So when Chief Justice Taney makes that statement, that's now still continued to be used today, which, by the way, that was the case. That was actually that was what started the Civil War. It was that case coming out, and as a result, that was the precursor to the Civil War. We don't want another Civil War, but I'll tell you, that's what they're doing today. They have an absolute untreatment of people. They treat those that have money, right, in this economic-based system. They treat those that have money better than they treat those that don't. Take a look at the bail system, right? I mean, the only reason why you go to prison is because you don't have the money to bail out. Because if you bail out, you've only got a 10% likelihood of going to prison. If you don't bail out, you have a 90% likelihood of going to prison. So you're being punished and sent to prison for no reason other than the fact that you are poor and cannot pay what they want you to pay to get out. That's the only reason. And it's disgusting. And these people need to understand that what they're doing is not based upon just principles. And therefore, we're not going to call them justice anymore. Because if you don't understand what justice is, and that justice is about equal representation, equal application, and equal then you're not justice. You're not just. And if they can't understand this, then that's fine. They're criminals, because criminals are one that transgress the law. So now we've got Chief Justice Taney. The third one is Chief Justice Waite. And Chief Justice Waite was a science experiment at best. He routinely misread the laws. He had a desire to proliferate the slave industry, and he put into place numerous rulings, such as Plessy versus Ferguson and the discrimination of the South, the lawful discrimination of the South, such as the slaughterhouse cases, which I'm about to discuss, and Crunkenshack versus United States. What he said in Crunkenshack versus United States, now this was after the 14th Amendment was enacted. The 14th Amendment, very first provision says, all persons born and naturalized in the United States shall be citizens of the United States and of the state in which they reside. Senator Howard introduced it to the Senate, and Congressman Bingham introduced the 14th Amendment to the House. And when they introduced this particular legislation, they went through and they said that the intent of this legislation is to, from henceforth, ensure that every single person born and naturalized in the United States are guaranteed those rights secured by enumerated in the Constitution of the United States, and that we have the states provide legal enforcement of these, right? So they found that they couldn't trust the states to actually give those rights that are guaranteed to people based upon their own volition. So they had to create some sort of a lawful need to force them into doing it. And so then they went through and they identified Article 4, certain rights that are fundamental to that particular part of the Constitution. But then they went through and they read every single one of the rights within the Bill of Rights. And so you would think that in 1868, when Congress of the United States comes out and says, yep, we are creating this law so that everybody in the United States of America is guaranteed these rights. Well, 3 years later, Chief Justice Waite comes out in Crunkenshack versus United States. And what he says is that those rights enumerated within the Bill of Rights are not a restriction against the federal government, only a restriction against states. Now, does that sound like a previous ruling? It sounds exactly like Barron versus Baltimore, right? So what Chief Justice Waite did was he went around the purpose of the legislation and what was actually stated on the floor of Congress, and he brought back in Barron versus Baltimore, brought it back in and said, no, we still don't care what you have to say. We're still going to not give those rights enumerated in the Bill of Rights. That was in 1868. And then it wasn't until 1925 that anyone was protected by any of those rights secured by enumerated in the Bill of Rights in the Gitlin versus New York case, and that's the freedom of speech. So today, what we're dealing with is a flawed foundation made by 28 justices that owned slaves and that placed into the foundation the enslavement institution. Of the first 28 justices that we had on the Supreme Court, they owned slaves. Therefore, their decisions that are the foundation of our just system are not based upon just principles, because just principles is about men being equal. Instead, it's based upon their desire to proliferate their industry and hide it under the name justice. So we don't have the term justice here in America. It doesn't exist. It will never exist, because justice is simply a term created by slave owners in order to preserve and protect their property. And that's the truth. That's the truth.
Wow. Okay, so another question. I know states, all 50 states have statute of limitations. So one question was, does the federal courts have statute of limitations on deprivation of rights or any of your rights being violated?
There is no limitation on statutes or statutory limitations on a constitutional violation. The reason why is because a constitutional violation is a deprivation of rights under color of law. Remember what I said the last time we talked. Deprivation of rights under color of law under Civil Rule 60 means that it's a void judgment. Anytime that a court acts without jurisdiction, in other words, once they breach that constitutional obligation, they do not have jurisdiction anymore. They don't have the authority anymore. And as a result, every action, every decision, anything taken by that court that lacks jurisdiction is void, wholly without force or effect on the parties involved in the dispute, because they did not have authority to move forward, because the very organization that's intended to preserve and protect those rights cannot become an accomplice in depriving of those rights. Therefore, there is no statute of limitations, because the void judgment is always and forever void. It can never be valid, and as a result, it can always be challenged, because there is no statute of limitations. Guys, once again, stop saying that you need to appeal your judgment. Stop saying that you're wrongfully convicted, because that says that these judgments are valid. They're not valid. So there's nothing more to say other than the fact that this has no enforcement, this has no applicability, and as a result, there's nothing more to talk about. Go after them. Because when you talk about appealing it, when you talk about challenging it, when you talk about that was wrong, you are going in and you're validating that judgment. And when you do that, now there is a statute of limitation. But there is a limitation when it comes to void judgments. So void those judgments and render them completely void without force or effect.
Which leads me into, how do you file a 42 USC 1983 claim against judges who have judicial immunity or absolute immunity? That's what they're saying. Prosecutors, CPS, where everybody. How do you sue everybody?
So again, let me be clear on this. There are three types of immunity, right? One is absolute immunity, one is judicial immunity, and one is prosecutorial immunity, right? All three of those. Please go out and read this. Please confirm this, guys. I need everybody to believe the things that I'm saying to you. What it says is it says immunity from civil liability for actions taken in the course of their business. So when a judge says that he's immune and he has absolute immunity, he has absolute immunity from being sued in the civil course of his action, of his duties, because you sue his master. But he is not immune from criminal liability. There's a difference. Criminal liability applies to the individual, the agent. Civil liability applies to the agent's master. So when he has absolute immunity, his absolute immunity only applies to his civil liability for the actions conducted in his business, because you sue his master, right? But he is not immune from his criminal liability. And that was stated by the United States Supreme Court in a case called Imbler versus Pacman, right? P-A-C-H-T-A-M-A-N, Pacman. So Imbler versus Pacman, 1976 says, even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivations of constitutional rights. Judges are not immune from crimes, because that would mean that they are above the people. The law applies to everybody equally, everybody. And when you willfully choose to violate that which you are bound to adherence to, then don't think that you're going to be protected by that object, because you offended the very object that affords you your powers.
The law will not protect you if you willfully choose to violate it, to oppress the very objects that the law is designed to protect. The law is here to protect the people, not the government. And government needs to understand we created those laws for our own protection from the government. So now we use those very laws against them and make sure that they understand that if you're going to be a criminal, you're going to be subject to people in the United States.
Okay, next question. How do you get off the federal registry when you have not been charged with child abuse and there's a quote unquote administrative finding, and now you're put on this federal registry that says you're an abuser because quote unquote the administration has found you guilty, not a criminal court, nothing, just an agency.
If that's void, then it doesn't need to be talked about anymore. Every action taken by any agent of government that is without force or effect is void. Therefore, you don't need to defend yourself. You're asking a question that is defending something that they did to you. That makes you a defendant. Defendants have to defend themselves. You have nothing to defend if what they did was unlawful in violation of the Constitution because it's void. Void. Deal with the jurisdictional issue. Deal with the voiding of the judgments. And when you do, the dust settles where it may. And where the dust will settle is that those actions taken by criminals that are unlawful in conflict with the Constitution don't exist anymore. Every action rendered by a court without jurisdiction is void, wholly without force or effect on the parties involved in the dispute. Again, go out and confirm what I'm saying. Civil Rule 60B4. Civil Rule 60 deals with the nullification of voiding of judgments. Civil Rule 60B4 says that a judgment is either valid or void. It's valid in all instances except for when the court rendering a decision lacks either subject matter jurisdiction or personal jurisdiction. If it lacks either one of those two things, it is a void judgment. Void. Go out and read it. You will find that exactly what I'm saying is true. And if it's a void judgment because they lack jurisdiction, then don't talk about the registry because the registry is all unlawful. It's all unconstitutional because it derives from an unconstitutional act. Deal with the nullification. Don't validate these judgments, guys. Stop defending yourselves. You guys have nothing to defend. You made yourselves free. Now exercise that freedom.
Now, this is the big one. Okay. How can a court terminate your parental rights when the United States Supreme Court has said the only way a parent can lose their rights to their child, termination of parental rights, is in sexual abuse, criminal abuse and neglect, and of course murder? Okay, that's a no-brainer. Okay, so how are these courts getting away with saying a parent is unfit and terminating their rights that clearly state sexual abuse, criminal abuse and neglect, or murder?
So Plato said that silence is your consent. Let me explain why it is your consent. Because when we're silent, when the people are silent, we allow the government to do things to us that they would not otherwise be able to do because we don't speak up and speak out and demand that they do things properly, right? That's our obligation. Therefore, our silence is our consent. We allow them to do things to us that they would not otherwise be able to do. But once you're informed and you're aware of their liability or their obligations, then you can speak up. Then you can say, you know what? I'm no longer going to I'm not going to consent to this any longer, right? But on the inverse side, when government is silent, that is an indication of its guilt because government doesn't want to argue something that they know that they're guilty of. Therefore, they don't validate it. They keep it silent, right? These are major issues that they don't allow us to talk about. Why would government not want us to talk about it? Because doesn't truth lie somewhere between two stories? So when they tell their side, which is based upon an allegation that's from somebody that wasn't even present, then don't you think that justice would presume to allow for the truth and both sides of the story to be told so that they can ascertain what is true and what's not? Absolutely. Only a liar wants just one side of a story to be told, right? So they're lying to the people and they're only telling one side of the story. The other side is not being told. And that's why we now need to exercise our right, because we all have the right to tell our stories. You have your right. She has her right. They have their right. We have the right to tell our stories, and we must exercise that right, not to get them into trouble, but so that maybe by exercising our rights and telling our side of the story, we can keep our country from ever having to do this again, because our country has a unique ability to be able to learn from its mistakes. But a nation can only learn from its mistakes by learning from the mistakes of people. We must tell the truth. Now, we got to tell it, right? We have to tell what they've done to us. And when we have to do it in a non-destructive manner, right? Because half the story was never told. So again, when you look at what's happening, we are not going to get the lower court to do what we want them to do, because business is too good for these guys. They're making way too much money, and they feel like you just said, they're immune, right? Oh, we're immune. We can do anything we want because we have absolute immunity. They don't even understand that they are subject to death penalty for every single one of these offenses that they're doing. Like this hasn't even grasped their understanding, because they say, oh, I'm absolutely immune. You guys are up for a very, very rude awakening, because you are not absolutely immune. We can't sue you because we can sue who employs you, right? But we can absolutely hold you criminally liable for your criminal acts, because you're not above the law. Once again, remember, judges are put in their position in our sovereignty. We are sovereign, and we create their office in our sovereignty by our ability to freely make that decision on our own, which means that we can freely remove them from that office on our own, right? They are the created. We are the creators. That which is created cannot be above the creator, because that's without even contemplation. That's like saying the peasant is above the king. And that's not true. We are above them. We tell them what to do. And we do that by not giving our consent, by speaking up and speaking out, by telling our story. Because remember, a patriot is defined as one who loves and defends his country, right? I feel like I'm as much of a patriot as this nation has ever produced, right? Not because of the wars that I say that we need to go out and fight, but because of the words that I speak. Because a true patriot knows that if you love something, then destruction should never be an optional outcome for that which is loved. I don't want to destroy this country. I don't want to trade one tyrant for another, but I want to make sure that our country has a future, and that future is secure, and that it's prosperous for all of us, because we adhere to the laws that bind us together. And if we don't, then I'm going to call them out on their crimes and let them decide what they want to do. Do you want to be a criminal or not? Because as a public official, I can't prevent them from exercising their power. But what I absolutely can do is let them know that should you choose to exercise your power without authority, that makes you a criminal. And if you want to be a criminal, then you're going to get the fuck off that bench, because criminals don't have the authority to sit in a place of honor. Criminals don't have the right to be able to lead our country and our people's country, because we are not a criminal nation. We are good people with good laws, as long as we have faith in those laws and we all treat people equally in the application of those laws.
Which brings me back to my very last question. People want to know, how do you get or go after a judge's bond? Because when they're asking for it, 9 times out of 10, the judge is mad, says you're disrupting my courtroom, puts them in jail, or says you're in contempt of court and they're in jail.
Yep. Schaefer does that.
Yeah,
so as I said in Las Vegas to U.S. attorneys a couple weeks ago, I sat there and I said, I am done going to criminals and asking criminals to stop committing crimes. Right? That's not getting me anywhere. I'm done going to a system that created rules that they themselves are refusing to adhere to. Right? I'm not going to do that, because that's not getting us anywhere. And just as Gandhi said it's not the oppressor that needs to hear the truth. They already know it and are busy concealing it. It's the oppressed that needs to hear the truth, and not the oppressor. Mm-hmm. If I spend my time in a courtroom arguing with judges and other criminals, right, I'm not going to get anywhere, because they're not going to change the things that they're doing, because they're going to take what I say to them and conceal it and continue to advance. It's the people of the United States that needs to hear the truth, right? They're the ones that need to be informed, not the criminals, right? And so again, when you walk into that courtroom, you say to the judge, you're breaking the law. Well, he already knows he's breaking the law. That's why he's a criminal. That's why he's committed perjury. Every single one of them is refusing to recognize the force of body laws govern this nation. They know it. Every single one of them, which makes every single one of them a liar and a criminal. And once you understand psychology, dealing with liars, there's certain things that you have to deal with. These are all a group of narcissists that want to project this image of perfection outside on everyone else. They want to talk about how perfect they are and look at how these other people are not perfect. That's projecting, right? We understand projecting. And so once we understand what they are, because you have to remember, perjury is an act of lying, which makes them liars. And when you deal with a liar, the way that you deal with them is with the truth. You tell them the truth. Because how many people walks in a courtroom and says, oh, Your Honor, Your Honor, Your Honor. But how many people walk into that courtroom and say, you know what? I'm not going to call you honor because you're not honorable. You're a liar and you're a criminal and you're committing more crimes than anyone else here, right? That's going to bother them. That's going to piss them off. That's going to make you contempt, right? They're going to say, oh, well, I'm not going to listen to this because you need to call me honorable. Because they have this image of their perfection and all this. We have to stand up when they walk in. They think that they're sovereign. They think that they're immune. They think that they're above the law. They're not above the law. So the way that we deal with their criminality is with the truth. You guys are criminals. And if you want to remain criminals, then you could continue to do business as you're doing it today. If you don't, then you will return to the established rule of law. You will return to where we're at, and we will resolve this consistent with the agreed upon conduct established by the majority. So when you go into that courtroom and you want to hold them accountable for their crimes, you will not get the outcome that you're seeking ever. Stop going to those courtrooms. Follow me to the highest court in the land, because that's the only court that will make a decision that's in the best interest of the entire nation. And the reason why is because those 9 judges, if they refuse to side with this, side with what's consistent with the law, one, they just told 330 million people that what they believe in is not real. So I don't think those 9 judges are going to have the balls to do that, right? Because I pray for what the outcome might be for those individuals should they make that decision, because it will not be a safe decision for them, because Americans believe in us. We believe in the Constitution. And when those people that are administering the Constitution and put into place to adhere to it say, we're not following it and we're not going to follow it, I don't think that they're going to get very far with that particular statement. So I don't think they have balls to do that. Second, they have a job that they will no longer have should they choose to not side with this. Because the only reason in creating that office is to recognize and enforce the Constitution of the United States. That's why they do everything in their power to prevent civil rights cases from being heard. Not because they're going to side against it, but because they already know that they have to side with it. So they do everything in their power to prevent it from coming forward. Every single step in this court system is an obstruction. Every single one. It's designed to make you disheartened. It's designed to make you go away, because for every 5,000 petitions that come forward, maybe one of them might get heard. Maybe one, right? You have to have the heart to do this. You have to have skin in the game. You have to have a faith that's beyond belief, because no one's going to believe you as you do this, right? No one's going to be there to support you. You have to believe in yourself and what you're doing and that initiative, because you will not gain support from anyone, because this is something bigger than that, right? So that court will absolutely make the decision consistent with the will of the people, because the outcome would be one that they don't want to experience. And so what we have to remember, when you go to the lowest court, right, you're going to the wrong court, right? Mm-hmm. So we need to remember what I said last time, that the issue of criminality or the issue of justice cannot be resolved from the bottom up, right? It must be dealt with from the top down. Because if our country is being led by criminals, people are acting outside of the law, outside of the established code of conduct agreed upon by the majority, and the very laws that create their office and give them their authority, then they are criminals. And as criminals, they will be leading us toward crime, because they're criminals. So they're going to lead us in one direction. And that's not the direction that we want to go unless you want to be a criminal. So you can follow criminals and thus become a criminal yourself if your leaders are criminals. And as a result, you will produce an environment of criminality, which will then produce a society of criminals. Or we can make a decision that we don't want to follow criminals. We want to follow the law, because we can choose to follow the law of man, or we can choose to follow the law of God, or the law established. We can choose to follow the Constitution. And when it tells us to go one way, don't go the other way. When the Constitution says to go to the highest court, why are you going to the lowest court? When the Constitution says that your judgment is void, why are you appealing it? When the Constitution says that it's the supreme law of the land, why are you going to case law? Because everything that they tell you to do is the exact opposite of the direction you want to go. Don't follow criminals. Follow the law. We all want to be lawful. We all want to then follow the law. Don't go into that courtroom anymore. Don't give them jurisdiction over you or your family. They have no jurisdiction, because the supreme law of the land has said and made very, very clear the procedures that you must follow. So when Congress creates an act of like 1925 in the Judicial Reform Act, and they say that the district court has original jurisdiction of any civil action authorized by law to be commenced by any person, an act of Congress to be constitutional must not conflict with the provisions of the Constitution. So when you're directed by an act of Congress to go to the United States District Court and you fail to follow the law, this is the supreme law of land that says that the Supreme Court of the United States has original jurisdiction, did you not just break the law? And you did it because Congress told you to? No, you need to follow the law. There's 4 pages in the Constitution, guys. You can know that. You don't need to know the other 800 million pages. What you need to know are those 4 pages. Follow that law, because that law told you to go to the highest court, not the lowest court. Start getting the mindset that what they tell you to do is leading you to criminality. Start doing the opposite. Just get in the mindset. Do the opposite of what they tell you to do every time. Then you're going to be going in a lawful direction. The laws that they protect and that they create are laws that remove freedom. Statutes, ordinances, customs, judge-made rulings. Those are laws that create criminals and they remove freedom. You want to be free? Go to the one law that guarantees your freedom, the Constitution. Study those 4 pages. Quit studying case law. Quit studying statutes. None of that matters because none of that is the Constitution. Therefore, it's all unconstitutional. Stick with the highest form of law. Come up to that level. And when they try to draw you down off of it again, return to it. Keep reminding yourself what the provisions of the Constitution say. Just keep reminding yourself. And every time that they tell you a lie, remind yourself of what the truth says. And when you do, you will cut through their bullshit and you'll win because they can't argue with the truth.
Right. And that's how I have been actually winning cases for so long. I don't win all the cases, and it's not me not in the courtroom. I'm telling people, right? The Constitution is the superior law of the land. Okay. It doesn't go state or count, whatever. It starts at the top. The Bill of Rights is a restraining order against the government. Use your constitutional rights, right? Yep. Which brings me to this. Now, some people, okay, like I would not go to court. Okay. I just wouldn't, because sometimes you got to suck it up, swallow the pill, and just go to jail for the cause. What happens when the sheriff shows up at the door with a summons or a subpoena? Okay. What do you do if you don't go to court? You know there's going to be a capias, there's going to be a bench warrant. What do? You
guys, I can't tell you in your particular situations what to do, right? Because I can't tell you to go against the established rule of law. This is something that you're gonna have to put into your own hearts, right? I have it in my heart. I know what's right and what's wrong, and I'm not gonna allow tyrants to control me through fear. I'm going to do the right thing. And I'm going to make that decision on my own. I'm not going to commit a crime. I'm not going to continue to participate in their conspiracy to undermine the laws of the United States. I'm not going to do that, right? So what I'm doing is I've taken it upon myself, just as Patrick Henry did when he says that I know not the will of others, but as for me, give me liberty or give me death, right? And this is a call for all of you to make a decision on your own. I understand that you have a family and that you have a job and that you have property. You have things that you can lose, right? And that could very well happen. It could. Mm-hmm. But if you believe in something but not live it, you are a liar. Yes, we must believe in something. And America is what we believe in. I believe in it. I don't think that we're going to destroy this. I think that we're going to be able to bring them back into compliance by making them understand their ignorance, understand that they've been led astray, understand the damage that is being done to the people of the United States and the union of our nation because of their ignorance in their acts. And I believe that there's none of them want to see the destruction of America. I don't think that they want to do that. Now, if we're wrong, then so be it. But if we're right, then we can do this. But we do this by bringing to their attention the fact that they're criminals and let criminals decide, do they want to be criminals? Because these guys, I don't think that a law enforcement officer or a judge or I don't think they take that position because they're criminals. I think they take that position because they honestly believe that they're doing good, right? But just as the philosopher Nietzsche said, he said, those that fight monsters should see to it that in the process they don't become a monster. Who is the monster? Justice. Why? Because if every single day all that you see is evil, over and over again, murder after murder after murder, right? If all you see is evil, then eventually that's all you're going to see. Mm-hmm. Law enforcement needs to understand that there is good in this world, right? Prosecutors need to understand there is good in this world. And they need to come back to the understanding that the world is not evil, right? But that's not all that's out there, right? And we can do that by just simply acting in a manner non-destructive, right? I don't want to trade tyrants. I don't want to send them to prison. That's going to be a decision that they're going to have to make on their own. But I believe in America. I believe in what we created, and I think that it's time that what we created is actually fulfilled. All men must be equal. We must start over. We must have a system that treats everyone fairly and equally. And we have an opportunity to do this with the litigation that we have, which means that if you guys, once again, if you'll put faith in the words that I'm saying, if you put faith in the law that I'm speaking, then get behind me and let me speak for you and your family, because I can do this. I can go to that court and I can make those 9 judges do what I say, because I guarantee you that they believe in what I'm saying just as much as you do. But we need to make them understand that what they're doing is destroying this nation. And we can do that. We can do that. We just need the voices coming up and getting behind this issue. This issue is that if a state chooses to break the law that the people established, then what they've done is unlawful. Therefore, anything that comes from that is going to be rendered unlawful as well. Therefore, every single act, every single judgment, all of these things that are being done by an unlawful act in breach of the Constitution are fully, without force or effect, they are unlawful. Let's tell them that.
And one last thing, I just have a statement. So I've been sending people to, email them, just send. Okay, so they're emailing you. You're not getting back to some of them. I told them you're very busy. Can you just tell them to be patient, please?
Yeah, guys, I'm very sorry, right? One thing is that we're constantly driving, and there's limitations even with that, but a lot of these roads down south, like through Texas and even Oklahoma, we don't even have service in huge swaths of land. Like when we were down in Florida, where we were at, there was no service at all for 4 or 5 days. And so, it's difficult for me to be able to keep up with that, because after being down for 4 days, when you have, 8,000 emails, it's overwhelming. And I don't want to say that in such a way that you guys think, oh, well, he doesn't have the resource to be able to do this, because I do. Because what this boils down to is coming forward and presenting an issue to that court. And so every one of you is equally important, right? I'm not more important in this task than any one of us, because we're all going to be working together to fulfill the outcome. As long as we can identify a common outcome for all of us, then we can all work to advance and reach that outcome. But, I've got a website that I haven't had built yet, because I haven't had the network stability to be able to do it. I've got affidavits that we've got to get put together, and I have not had the time to be able to do it. We can all work together. But one thing that you guys need to understand is that if you believe in the things I'm saying, then support me and understand that I'm just one member of this whole group of people that's coming together to kick the shit out of this government, right? Right, and to put them into their place. So I'm simply speaking, right? I have the words based upon the law that I've collected from all of you. I want to go and speak those words to those in power and overcome this. But you can take my words from Facebook. You could take my words from Rumble or any one of these, and you could say, you know what he just said meant something to me. That really applies to me in my life. And if it applies to you in your life, then I guarantee you that there's thousands of people just like you that would love to hear the words that I said that meant something to you. You guys can take that and get it out there, because what I say, I don't take credit for it. It's not my words, it's our words. You guys can take this because what I'm giving free, I want all of you to have for free, because the best thing for all of us to do is to have the knowledge and understanding so we can all come up together. So I'm not selling this. I'm not asking for you guys to hire. I'm saying that what I have for free and God's given to me for free, I want to give free to you guys, and you guys take that. And you guys freely give it to others, right? Get this information out there, because even if you don't say that it's from me, it doesn't matter. What's important is that people get this information. That's what's important. So, right. Rather than looking at your own situation and saying that this is unique, it's horrible what's happening to me, understanding that what is happening to you is happening to thousands of other people just like you, because tyrants are all exactly the same. So when I say things that mean something to you, find a way to take that information and give it out to your group there, because your group, I guarantee you, share common issues and concerns that you have. That's why you're in a group with them, because you have a common issue. So I'm sorry that I'm limiting my ability, but just know that what I'm doing because I love all of you, because I love my country. And how can one say that they love their country if in the same breath they do not say that they love their fellow countrymen, right? Because your country is simply an aggregate of the people. I had to learn how to love all my brothers and sisters here in America. I want all of you to do that. And so the way that we move forward is by helping our brothers and sisters overcome the obstacles that's been placed in their life. So thank you guys for letting me serve you and your family.
So it looks like we got 2 people that can help write affidavits. Spanny, do you see that? Kim Brown and Tyler.
I would love all the support that we can get. So again, we're at 1% on the phone, so we're gonna have to be done here in a moment. But
That's fine.
So my email is readily accessible. Anybody, you can send me those messages, and again, I will respond, and I'll get better, especially when I get to a place of some stability, which I hope that's where we're going right now. But my email address is my first name, TANAWAH at weshallbefree2023.com. Amber here is Amber at weshallbefree2023.com. My phone number is out there, is readily available. But we have some people that are working on a fillable form for these affidavits where we can just collect the information. You can go to a website, be able to do it. Again, we still have a national interview that we're getting ready to do. I have to have this fillable form in place because I'm not gonna be able to support the numbers that are gonna be coming in on a rapid scale. So that's been a priority right now, is making sure that we get the fillable form done out on the website, get the website launched, so that when we do have this interview, that it's ready to receive the information and content that we have coming in. So, again, reach out to me and us, and as soon as we reach someplace stable, hopefully we'll have a lot more assistance. There are lots of people that want to help, and I would welcome any sort of assistance that you guys can have, because again, this isn't my pursuit. I have one area where I specialize in, where I'm very, very good at, and that's the law. But I don't specialize in content creation. I don't specialize in social media. I don't specialize in even communicating with people, because what I say is typically, information that most people glaze over, and it's too detailed and content. But I have a very specific purpose in all of this, as do each of you, and I appreciate the role that each one of you play, because I cannot do my job if you aren't doing your job. So we can all come together, and we can be very, very successful in this if we all recognize that we're in this together.
Put it on your.
I guess they're about to. Spanny, turn your mic on. Oh, I can't hear you again. Well, I guess their phone died. So, everybody, his email address is there. We all need to jump on board, and we will do another live next week. We will plan it, and we will send out the notification. I think Spanny wants to say something. I guess Spanny's coming back on in a minute. And I'm reading some of your comments. I can't read and listen at the same time. Wow, a lot of your stories are all the same. It's a whole pattern.
Can you hear me now?
Yes.
Okay, I do want to say I am not going to be telling everybody where they're going anymore. I am not going to be telling you guys when we're going live. I'm just going to put it up there a day before, because their safety is number one.
That's right.
I am also responsible for their security and keeping them safe. So if anybody's after them, they need to look at me, not them. As far as the negative things, all we can do is try. We're going to go out there and we're going to try. We know there's retaliation, and we are prepared for it. You can't do this without knowing that there's going to be retaliation. You can't do this without a backbone. You can't do this without making sure, things are properly prepared. I'm well protected. I'm not worried about that. I know Tiffany's well protected. I think everybody would be insane to try to attack Tiffany. Tanawah and Amber are going to be very well protected. And I can't tell you when they're coming. I can only tell you when they're there. And when they're there, I'm not even telling you where they're staying. Tori, is there a general template and information that could be substituted? So are we talking about a template for a website or a template for an affidavit?
And
Start answering.
anybody on here, I'm waiting on Tori to respond. Anybody on here that can help with affidavits, court papers, whatever, get in touch with me or Spanny or Mr. Downing or Amber. But if you can help us, that'd be great. I don't
Anita, I
know.
know you're excited.
What'd you say? Oh, she said a template for an affidavit.
Yeah, okay. Yeah, Anita, I know you better be protected.
Yeah, right.
That's my attic troll. Jamie, I think we need to get together with you and talk. I've been seeing what you're saying, and I think there's stuff that we can do to help you. I know you were an advocate, but I think there's stuff that we know that might be able to help you, because everybody has a strong suit when they're an advocate. Everybody has a little bit of a different background and a little bit of new ideas that work.
Well, why don't we have her on our show on Sunday?
Okay.
Get with her and find out. We'll go live again.
Yeah. Do you want exhibits attached to the affidavit? Yes, he does. Kim.
Kim, yeah, get in touch with us. My email address is,
She has my number, my email. We talk a lot.
okay, well, you can give her mine too. Yeah, we can have her on Sunday. We can have up to 6 people. So
Yes.
if anybody wants to come on Sunday, we can take 4 people. Let Spanny know, since she's my co-host and she's more
Yeah.
electronically better than me.
You remember Kim? We used to have her on with Dawn all the time.
Okay, well, we'll get her on too.
Scroll. Barbara. So this is one I wanted to try and say, but he didn't really have the time. They are taking her disability for child support.
What?
That is federally illegal, and you can get the an advocate disability person to actually go after them.
Yeah, you actually want to get in touch with Mary Love on that, because she knows about the disability part. But you can also file a federal claim, because child support is federally funded through the states, which means you can go to state or federal.
So how do you avoid a judgment? Well, what I was always taught is you take that paper that they give you that has been illegally given to you because it has stuff that's not true in it, and you write void in big bold letters and give it back to them.
Oh my, these things are coming in faster than I can read them.
Okay, hold on. Let me scroll down. I was trying to catch a couple of questions I wanted to.
Okay.
Jamie, we will talk to you on Sunday. And I know you can help, Kim. Kim, you, me, and Tiffany will get on the phone and talk about how you can help, okay? And Nita, yeah, Nita's on disability. They know they can't. Yep, it's very illegal, Kim. Sorry.
Also, look up United States versus Sage. It deals with child support. United States versus Sage.
With how much time do you have to turn it back into them when you do the void of judgment? Usually about 10 days is the legal thing.
I would do it right there.
Yeah, so would I, but. Oh, I think, okay, sorry, Kim, I think your phone ran away with that one. And be sure to get the internet on the money that they have kept. I'm thinking she's making sure that what she's trying to say is keep tabs of how much they've kept of your money.
See, this is what people need to understand, right? That these people have a pattern. I'm a pattern person, okay? Like each one of my grandkids and each one of my kids, I know what their patterns are. It's the same with CPS, child support, the courts. It's the same. You have to watch their pattern.
That is normal, Jamie. They go after people with disabilities all the time.
Yep. They sure do.
Tyler, red or blue ink? I'd put it in big, bold, red letters.
It's either blue or black, but whatever.
Screw it. Screw it. They're screwed up. You might as well put it in big red letters.
With a Sharpie. With a Sharpie.
Yep, with a Sharpie. Make sure it's a red Sharpie and
No, blue or black. Come on. Let's get legal with it.
why? They're not.
That's beside the point. Just because they fuck up doesn't mean we have to.
Sorry, my back room person here.
That's okay.
Interest, yeah. Like I said, I think your phone ran away with it. I know there's more questions out there, guys. Hit us. Okay, don't physically hit us, but hit us.
Why is the sky blue?
Don't mind the smart ass in the background.
Hit us with questions. I've hit you. I don't know.
I know there was other questions up here. You have fun with that, lady. I'll be looking forward to the papers you bring home to me.
Huh?
Good luck, Nita. Tell Jason I said good luck.
Oh my. All right, so Spanny, you're going to set up our live with me and you and some of these people for Sunday.
Yeah, what time's good for you?
7:00 my time is good. And on Sunday night, it's better for me on Sunday nights. On Monday through Friday, it's better during the week.
Four, my time?
Oh my God, I'm having a blonde moment. Monday through Friday, early afternoon is best for me.
Yeah, I'm sitting there going, so
I know.
that's like 3 my time, I think. Yeah.
Well, you set it up. And
Yeah,
with
that's
that,
cool.
go ahead, Spanny.
Is there anything that the appeals attorney should be asked? You're not going through the appeals. What Tanawah was saying is you guys need to go to the federal court. Skip
Don't
the appeal
appeal
court.
it. Don't appeal it.
I've been saying that since day one when I started this, not to play with the family courts. Tiffany can tell you, I flat out went up to the Supremes. I wasn't dealing with them.
Yep. I
And-
hate family court.
And because of that, I've gotten 199 children home across the U.S. because I wouldn't play their family game.
I will tell you this. If any of you are in Virginia, they did a whole write-up, a whole article about how the federal courts are not seeing as many cases as they used to, and they want cases. Start filing in Virginia courts, federal courts. There's 4 federal courts in this state. Find your district.
Tyler, no, you need to go straight up the chain. Don't even write void on that document. Just go straight up the chain.
Yeah.
All it takes is 5 violations in your court documents to go up there. So you can read through it. If it's more than 5, awesome. It'll look better. But that's all it needs.
If they go back and watch the first live we did, he tells you how to do it in federal court. He tells you everything that you need. How the conspiracy works, the fraud, everything. Go back and watch the first video.
And you see, the good thing about going back and watching is you can pause it and write stuff down.
Yep. And I tell people this, Fanny tells people this, don't take our word for any of this. Do your own research.
I got told by so many advocates I couldn't go up to Supreme Court and do what I'm doing now.
Why?
I couldn't get kids back because you have to go through the chain of courts. Guess what? I've got 199 kids home doing it my way, going up to the Supreme Court.
Well, if people look at it like this, TANF is federally funded, right? Which funds CPS and foster care. It's automatically a double jurisdiction. Nobody said you had to go to the lower courts. Anytime federal funding is involved, it's also a federal case.
Yeah, like there's a couple of federal cases that are in process right now. One's in Alaska that I'm helping with. Another one is down in West Virginia because West Virginia is my problem child. Everybody knows that.
Texas is my problem child.
Tiffany, not this Tiffany, but my client Tiffany is getting ready to get thrown in jail by Judge Stephen L. Schaefer because he's, well, doing everything illegal again. So what they're doing is they tested her child, a hair follicle test, and it came up with 3 drugs that were in this 2-year-old system when she was first born, and they were trying to say that, okay, well, you must be around drugs again, which she wasn't. The baby's never been around the drugs. So if you go back and you read hair follicle testing, they are not allowed to use that in federal court, period, let alone family court, especially on a baby or a 2-year-old due to the fact that they are still growing. They have not gotten everything out of their system yet from when they were in the mom's womb. Yes, she admits it. She was wrong when she was pregnant and doing drugs. Okay, she admitted that. She got clean. She cleaned up. And I've been helping her with this off and on. Now, everybody knows I really don't take cases that have to deal with drugs. I don't like doing it. I think there's a lot of rehab people out there that will advocate for the drug user because it's just a thing. I've taken on 2. One got her kids back. One is working on getting her kids back, but Stephen L. Schaefer is in the way. So we're going to have to do this by probably going up the food chain. If she gets thrown in jail, I have people that are going to go help her. But I wish you guys would pray for her because she's really freaked out over this. She doesn't want to lose her child. And they're doing everything illegal. They cross-contaminated the drug stuff when they were testing. They used the same stuff that they were using on her to take the baby's stuff as well. You're not allowed to do that. If the drug facility does not open that package in front of you and it's already open and set out, you say no. You tell them that they need to get fresh stuff out in front of you and unpackage it in front of you. There's a lot of cross-contamination, especially in Kingwood Corrections in West Virginia. But any other questions?
Sorry, Spanny, I had to take that call.
No problem. But yeah, did you hear that? Did you hear that? They were cross-contaminating the drug stuff, the drug testing.
Look here, man. Look here. The high courts have already said, just because you use drugs, and I don't like drug cases either. I'm just going to tell you, I don't agree with them. Okay, because I just don't. I'm not a drug user. Anyway, the Supreme Court and the higher courts have already said, just because a parent is a drug user does not make them unfit. But anyway, that's a whole different show. You already know we went over those.
Yep, 154 of them actually.
Yeah.
But no, my client Tiffany, not this one, she's really scared, and they are doing everything in their power to take her little blonde-haired, blue-eyed baby.
Oh, imagine that. And the child is under 5.
Yep, she's 2.
Adoptable.
Yep. But we got the right people on this one, so she will be safe. Even if she gets thrown in jail for a little bit, once she's bonded out, we're going to hit them hard.
And see, that's something, you know, I can speak on this. To do this, really, like Spanny said, you have to have a backbone. And sometimes you got to bite a bullet and you just got to sit your ass in jail. I mean, if you really stand up for yourself, because even though Spanny, me, Mr. Downing, we're all these advocates out here, we can advise you and teach you what we know, but it's up to you to execute it. And sometimes you just have to sit in jail for the cause to let people know, especially judges and lawyers, that you're not playing, that you're willing to go to jail, to stand on what you believe in.
But also have a backup plan. Like, my client, one of my clients, she has a backup plan that as soon as she gets thrown in the handcuffs to taken away, she has somebody that's going to get a hold of me, and that somebody is also going to give me all the information that I need to help get her out. I always have a backup plan. I have people that send me flash drives of their cases just to hold on to, just in case something happens. I have people that do living wills on video and send it to me to keep safe. It's all part of the game. You have got to have a backup plan to fight these guys.
Yep. Well, if there's nothing else, be prepared. Prepare her for jail. I have been there. I've been there too. I graduated. I went to prison.
Yep.
All right, Spanny, whenever you're ready, we'll do it. You just contact me. We'll do it on Sunday too with these other people.
All right. So I'm going to end this, guys, and we will all see you Sunday at 3 p.m. Alaska time, 7 p.m. West Virginia time. If you're somewhere in between there, make adjustments.
All right.